So we'll reconvene. Jack Balkin, who will present the principal paper, is Knight Professor of Constitutional Law and the First Amendment at Yale Law School and is the director of Yale's Information Society Project. Yochai Benkler is the Berkman Professor of Entrepreneurial Legal Studies at Harvard Law School and faculty co-director of the Berkman Center for Internet and Society. And Dawn Nunziato is Professor of Law at George Washington University Law School and co-director of the Global Internet Freedom and Human Rights Project. So everybody is both a teacher, a professor, and an institute director. Whatever that is.
What I've always wanted to do is direct. Hello, everyone. How are you this afternoon? Did you get some coffee? Hello, that's very nice. All right, drink up. It was going to be a while. Now, I've got to... I'll try and do a short version of this talk. I'll try and keep you entertained. We even have a little dancing there for you. Dawn's talk will be about dancing. The reason why Dawn's talk looks like that is because I start the piece by talking about a quote from John, in which he says that the New York Times versus Sullivan is an occasion for dancing in the streets. And that's, there's a segue from this. And you got to remember, he's like 89 years old at this point. So you imagine John dancing in the streets. But in any case, that's actually a good segue because when you think about dancing, dancing presupposes streets in which to dance. It presupposes an infrastructure. The idea is, one of the big themes of the paper is the fact that freedom of speech and press always presuppose a kind of infrastructure. Sometimes the infrastructure is obvious, sometimes it isn't. If you think about New York Times versus Sullivan, you think about New York Times. The New York Times is not just simply the print on the page. It also involves an entire editorial staff, and you have to have a building to house them, and you have to have printers and printers unions, and you have to have delivery trucks and advertising agencies and all these and economic infrastructure that allows that to happen. And that's, mid-20th century newspaper. And if you look at free speech doctrine from the lens of infrastructure, you can start to see interesting things. So, for example, practical freedom of speech not only depends on that, it depends on things like public libraries, and it depends on postage subsidies, and it depends on a whole bunch of different things that make it possible for ideas to circulate and people to express themselves. And many old chestnuts of First Amendment law are actually attacks on the infrastructure. So the classic is the Hague case in the 30s, in which Boss Hague tries to shut down the CIO by denying them any place to meet in public. So it's an attack on the infrastructure in terms of space. Grosjean is a tax on newspapers, basically going after the printing press. There are other, there's the Schneider, which is a ban on handbills. This is an attack on a particular mode of expression. So lots of old ones cases can be understood in terms of the government, instead of going directly after speech, it goes after infrastructure. Now, this leads me to the next big idea and leads to the title. There's a distinction now between the way in which speech was primarily regulated before the digital age, and new ways, new techniques that you can regulate it. So that's why I call it old school, new school. How many of you are fans of old school? There you go. Old school, new school is also the name of an LL Cool J rap many years ago, probably. Who is LL Cool J, you're saying? But in any case, so I distinguish between old school techniques and new school techniques. Old school techniques are the pre-digital techniques in which you go after bodies, you go after spaces, you go after pre-digital techniques of publication. And new school techniques, which don't displace old school is still around, it's still in good taste. New school techniques are all aimed at digital infrastructure. There is a digital infrastructure that's actually necessary for speech to occur today. It's obvious to you, probably, you live in this digital age. It includes the computer that a fellow is typing on, the software protocols that help the computer run and connect to the internet, various kinds of standards that allow documents to be processed, routers and cable and wires and wireless techniques, and the DNS system and software systems, and I could go on and on, but if you think about it, and then beyond that, beyond the hardware, there are things like institutions, there are advertisers, there's payment systems, electronic payment systems, there are search engines, and as we start to think about what is the infrastructure that makes digital speech possible, what we see is this rather large and variegated set of technologies, practices, and institutions which together create the digital infrastructure. And so new school speech regulation, instead of going after the traditional old school target of the speaker or the publisher, or right, you go after the infrastructure instead. So I was going to talk to you a little bit about some of the techniques of new school speech regulation, and I'll go through them. But one of the things I want to point out for you to think about is the following, that old school and new school, I'm using them to distinguish them, one doesn't make the other disappear. In fact, they supplement each other. They often exist together. So take the whole Edward Snowden affair. You can have, they're very much worried about Snowden's leaks, so what do? They engage in very old school techniques. They bring down an airplane hoping to catch Snowden's body on it, right? They detain, the British version of the NSA detains Glenn Greenwald's spouse, thinking that he's an old school courier, right? And so they detain him with the idea of searching him to get material off of him. And so that's old school techniques used for new school purposes, or what happened to Chelsea Manning, in which, in essence, Chelsea Manning leaks an enormous amount of stuff, and what they do is they put then him in a military prison for a very long time, even before being charged, with the idea of basically sending out, making an example, and saying, you know, you mess with us, we will mess with you. So it's not like old school goes away. It's still there, still there. It's still very much in good taste. But the question I'm interested in is, what are the new school techniques? So, and one of these new school techniques you'll see are variations on a theme. They're in some way interesting variations on the idea that is one of the oldest ideas in freedom of speech, which is the rule against prior restraints. So many of these new school digital techniques are some variation on the changes on the reasons why we think prior restraints are troublesome. So let me talk a little bit about them. First, an old school technique is what we might call collateral censorship. So if you think about it this way, when you have a relatively small number of media companies, newspapers, broadcasters, the state can either own them all, which it does in some countries, or it can license them, or it can use connections of family and economics in order to co-opt them. And when there are a relatively small number of journalistic organizations, it's not that difficult for the state to essentially have continuous relationships with them that essentially sort of keeps control of them through co-optation. And we've seen this not only in the United States, but in many other countries as well. But imagine that you change the infrastructure of free expression and you multiply the number of speakers, and there are speakers from all over the world. And what happens is that these traditional strategies of co-optation and control no longer available. So instead, what you have to do is you have to go after infrastructure. So instead of going after the speaker, you go after the platform, you go after the infrastructure. And one way you do that, a very familiar way, is one that we were talking about this morning. It's the inverse of the Section 230 immunity, which is the idea that I call collateral censorship, a term coined by Michael Meyerson many, many years ago. And the idea is simply that instead of going directly after speaker B, you go after conduit A or infrastructure owner A who houses or hosts or delivers speaker B. The idea is because A and B are not the same speaker, they have differing incentives, and the result is that A will block or over-censor B for you, right? And collateral censorship is in fact one of the most important new school techniques. Another technique has to do with forms of digital prior restraint. And here I need to stop for a second and tell you a little about digital restraint that you may not have known. If you think about digital prior restraint, you probably are thinking New York Times versus United States, Pentagon Papers. You're thinking judicial injunctions. yay, in about 5 years or so, we're going to have another conference. It'll be 2017, or 2021, I'm sorry. We'll have the 50th anniversary of Pentagon Papers. But the thing to understand is that prior restraint is more than just judicial injunctions. Prior restraint refers to systems of licensing or control, many of which would be administrative. They don't even require judicial injunctions. And they have important characteristics that are really interesting and important for the digital age. Let me just explain. One of the things that makes a prior restraint, for example, is that the state, restricts first, gives permission later. So it flips the idea of you give permission first and then you punish later. And by restricting first and giving permission later, what you're doing is you're creating a deliberate overbreadth of coverage, because everything is brought in and then you let people speak as needed. Secondly, the important thing about a prior restraint is it shifts the burden of inertia and inaction. That is, if somebody speaks and the government does nothing, well, they get away with it. But with a prior restraint, the government has to do something for you to be able to speak. So in other words, all the burden of inertia is against you. Third, prior restraints had limited kinds of enforcement procedures, often extrajudicial. They didn't have the full panoply of protections, which you get if you're arrested for a crime involving speech. Fourth, one of the things that's crucial about prior restraints is that they're usually low visibility. If somebody's arrested for speaking, there's a public trial, and people will pay attention. If, on the other hand, you can't speak until you get the permission of the government, that's not news. That's just low visibility, and in fact, it works better that way for the government. The government would prefer that a prior restraint be low visibility. Fifth, it shifts the burden of error costs, which is basically, the government doesn't want to make any mistakes, so basically bans everything. And so if it makes a mistake, the burden is on you, it's not on the government. And then last but not least, really quite important, is that prior restraints work by forcing people to identify themselves. They increase the ability, they actually promote self-surveillance. So in other ways, suppose the government bans and says you cannot speak until I let you. Well, then you have to show up and say, here, hi, I would very much like to say something that you won't like, right? And then you have to identify yourself, you have to make a big deal about it. And then, of course, if you don't wait, but if you speak without given permission, you get a kind of Cartman problem. How many of you watch South Park, Cartman has a catchphrase, respect my authority, right? So the problem is that if you speak without getting permission, it's like you're dissing the authority. You're not respecting their authority, and so they'll come after you. And which is not true if you violate a criminal statute. You violate a criminal statute, the prosecutor thinks, well, I mean, what else do I got to do today, right? I've got the following other crimes I have to deal with. All right, let's forget about it. So it's all these flippings of burdens that are characteristic of prior restraint. Why is this important? Because a lot of new school techniques, even if they don't involve judicial injunctions, involve these 5 characteristics of prior restraint in different ways. So here's number 1, filtering, right? Think about filtering, either direct filtering by the government or basically the government colluding with private parties to engage in filtering. It has many of the characteristics of a traditional prior restraint. It's deliberately overbroad. It gives you no hearing before the fact. It's very low visibility, and it shifts all the burdens of inertia and action onto you if you're the speaker. Another example, which I think is, totally cool now, right? It's domain name seizure. So the good folks at Homeland Security have an operation in our sites, get it? In which what they'll do is they hear that a particular website is engaging in copyright infringement, so they will swoop down. Now, they are not jackbooted thugs, because in fact, some of them dress in very stylish pumps, and some of them have lovely accessories. So I just want to say, but anyway, they swoop down with their not knockoff Prada handbags, and they closed, they seize the domain name so that it doesn't resolve, right? So they take over the domain. So it's going after the infrastructure, you see. And It's really interesting because it also has all the key features, right? You often have collusion between private industry and the government. Its secret proceedings are often ex parte. You can't do anything until they basically lift the seizure. In the meantime, all the burden is on you, and basically there's almost no judicial protection. It just happens. It's really very much like a classic prior restraint, only it isn't called a prior restraint. Another example, how many of you heard of SOPA and PIPA? That is not an ice skating team from the Sochi Olympics. SOPA and PIPA. No, it's not. SOPA and PIPA were two statutes that were, well, maybe it was an ice skating team. I'm sorry. Anyway, they were two statutes that almost were passed by the United States Congress, which were designed to completely reorient how you enforced intellectual property online. And SOPA and PIPA have a delightful set of ingenious new techniques for getting at pirates. And some of them I can't go through all of them. I mean, it's just a very long statute. But a lot of them had different forms of digital prior restraint. So, for example, one of the techniques was if the Attorney General alleges that you've got a foreign infringing site, which is defined in a crazy way so that it actually includes some sites that are not foreign infringing sites, then it can get an injunction. The injunction would be against it, and then the whole idea is that it will essentially cause the party, in order to lift the injunction, to engage in collateral censorship. So it was an injunction designed to get you to engage in collateral censorship. A second move is if you get the injunction and the site is overseas and you can't actually reach it, then you get another tool, which is the Attorney General will be able to go ex parte and basically go to various parts of the infrastructure, payment systems, advertisers, search engines, and basically serve them with a sort of like a mini injunction saying you must block or not do business with this group. In fact, you could actually go to certain kinds of internet service providers and say don't resolve the DNS for this site. So you could, as they said, break the internet. The Attorney General would have the power. So this is also the use of prior restraint. And there were other great ones. I mean, one of my favorites is what I call private prior restraint. So what you could do is, if somebody alleged that your site was dedicated to the theft of intellectual property, and by the way, you're not allowed to put quotes around it, but you have to say it in a very low voice, dedicated to the theft of intellectual property, then what would happen is that person, this is a private person, this is not the Attorney General, could send a letter to advertisers and to payment systems saying, don't do business with this person or you'll be in trouble. And that's what it would, on the paper it would say this in a low voice. So this was also, what was interesting about it is that it also used prior restraint, and it was completely ex parte, but it wasn't even in front of a judge. Right? So it was prior restraint plus ex parte plus completely private action. So this was totally cool stuff. And believe me, SOPA and PIPA were, they weren't passed, but they'll be back. Believe me, these techniques are so good that people are going to want to try them again. So that's why it's really interesting to think about this in terms of the techniques of prior restraint. So what other new school techniques are there? Well, I'm glad you asked. So let's go back to old school. How many of you ever heard of McCarthyism? Have you ever heard of McCarthyism? It involved that ventriloquist and the dummy? No, that was Charlie McCarthy, sorry. And the Playboy model? Well, that was Jenny McCarthy. All right, anyway. So McCarthyism is a particular period in American history in which everyone's very afraid of communists. And so the idea is the government holds hearings to try to root out communists, and then private parties who want to be helpful to the government say, we'll find communists for you, and then they have various kinds of blacklists to prevent, in Hollywood and the arts and the professions and so forth and so on. So this is the idea of what we might call public-private cooperation and co-optation between the government and private parties, and the creation of blacklists. Well, you can do this too, actually, new school. So there are new school versions of this, although we wouldn't call them McCarthyism. You can have all sorts of interesting forms of public-private cooperation. For example, your internet service provider or your infrastructure provider can provide data access about you to the government, right? Because after all, you might be a suspicious character. The government, in turn, can give them immunity if they provide the information or access to information about them. The government can give you immunity if you engage in collateral censorship. Or even better, the government can give you immunity, as they did in a previous statute called COICA, and later in PIPA, if you create a blacklist of people that you will refuse to deal with, and the government will hold you harmless for creating and enforcing the blacklist. And then finally, everybody's favorite, well detailed by Yochai Benkler over here, is a new form of soft power, in which you have an entity, let's call this entity, let's give it a name, let's call it WikiLeaks. And the government cannot actually go after WikiLeaks for a number of reasons. First of all, there's the fact that it's not accessible because it's overseas. But second of all, First Amendment. And so what it does instead is it just casually drops hints to various players in the infrastructure that it would be very nice if they stopped doing business with WikiLeaks. And then, right? So some of these can be public. So my friend Harold Koh had an ingenious letter that he sent out, which was basically designed to convince people to stop doing business with WikiLeaks. The Washington Post wrote an article saying, if you want to work for the government, don't you dare go to the WikiLeaks site. You'll never get a government job. And then my senator, Senator Lieberman, made some speeches, and then he called up various folks at Amazon and let it be known that it would not be well received if you were to do business with WikiLeaks. Right, so this form of soft power doesn't actually require any government orders at all. It's just all done through, suasion. How am I doing on that? Okay, that's not bad. I have one more basically thing to talk about. How many of you have heard of national security letters? How many of you received a national security letter? You're not supposed to say. That's the whole point. As a result of the Patriot Act, somebody was holding up his hands. I have. We arrest you. As a result of the Patriot Act, right, the use of national security letters has been beefed up. And so one of the interesting things about this, and it's really where I want to close, is it tells you something really interesting about new school speech regulation. And here's a way of looking at it. In the last 20 years, the government has entered into a new phase of governance that I call the national surveillance state, which involves an enormous amount of building up of surveillance capacities in order to solve various problems of governance. I don't care whether you like it or don't like it. This is a fact about the nature of governance today. We have a national surveillance state, and it has a very interesting consequence, which is that since most of it's interested in what people are saying to each other, the messages they're sending and communicating. The national surveillance state lives off the collection and analysis of that kind of data. But most of the infrastructure of free expression is held in private hands. And what that means, therefore, is that the only way you can have an effective national surveillance state is that the government basically has to cooperate with or basically bring in, right, or commandeer the private infrastructure of free speech in order to engage in surveillance. So that's another reason why one of the things I say in the paper is that the infrastructure of free expression is merging with the infrastructure of surveillance and the infrastructure of regulation. They've all become one thing, which was not true, by the way, in the mid-20th century. They were separated in interesting ways. And what happens then is, in order to make this work, you have to go to the private infrastructure owner. There are several ways to do it. You can do it through Section 215. You can go through Section 702. But in this paper, I focus on the national security letters. You serve them with a national security letter, and along with the national security letter, you give them a gag order saying, we never had this conversation. You don't have a gag order, and don't tell anybody that either that you have a gag order or that I told you don't have a gag order or that we had this conversation. Right? So you can't talk about it. Why? Well, the government's view is that we ask you to cooperate with us and provide data, and you were then to blab about it, right? You would basically scare off the people that we're trying to collect the data on. So it would completely undermine the whole point of surveillance. So the national surveillance state basically requires that you have gag orders that accompany them. Now, here's the interesting thing. If you studied and they're prior restraints. I mean, the thing about NSLs is they're not even, you don't even go before a judge and get an ex parte order, which you can do for Section 215 and Section 702. For the NSL, you just, you go to a guy higher up in the FBI and say, sign this paper. He says, okay. And then you take it to the infrastructure owner and say, here's your gag order. I'm sorry. Here's your NSL. Here's your gag order. Now shut up. Now, the thing that's interesting about this, well, there are so many things that are interesting about it, but it has all of the earmarks of a prior restraint. It is a prior restraint. It's even worse than a prior restraint. You don't even get to go before a judge. And it used to be until the 2004 amendments that there was no judicial remedy. You couldn't even complain before a judge if you got it. After the 2004 amendments, you can, once a year, go in front of a judge and say, I would like to have my gag order lifted. And although technically the government has to come up with a reason, it doesn't have to come up with a very good reason. And the judge pretty much has to accept whatever the government says, and then you wait another year and you do it all over again. And so that's the post-2004 situation. And so if you learned the black letter law of the First Amendment and prior restraint, you would say you have gone into bizarro world. Because we all learned, and I'm looking at David Anderson right here, that prior restraints are extraordinary, they are rare, right? You have to meet the most extreme burden. This is Pentagon Papers, right? And they can only last the absolute shortest time necessary to stabilize the situation, even if you let them at all. But what we have is a new system of prior restraints that are all done through bureaucracy and administration. They are ubiquitous, right? They are not rare at all anymore. They don't require very much justification, and they last forever, right? And so this is the new system of prior restraint we put in place in order to make our surveillance system work. Now, I should just tell you, right now in the Ninth Circuit is now trying to figure out what to do with this mess. The Second Circuit was faced with this several years ago in a case called Doe versus McCasey, and they essentially rewrote the statute. But the way they rewrote the statute doesn't even pass the Friedman versus Maryland test, much less Pentagon Papers or Nebraska Press. So they had to basically water down from Pentagon Papers to Nebraska Press to Friedman versus Maryland. They had to be even less than Friedman versus Maryland in order to make this thing constitutional. And of course, the Ninth Circuit is facing the same problem. And it's a really difficult set of problems because if, in fact, you applied even Friedman versus Maryland, which is the rules for dirty pictures, you couldn't have a surveillance system. It won't work because you will not be able to deal with the thousands and thousands of NSLs that are given out each year. Part of the story, of course, is that most of the people who receive the NSLs don't want anyone to know they've received them. Why? Because they're people like Google or Yahoo, and it's very bad publicity for them to know how many NSLs they've received. They'd like, in some sense, to be able to report that they've received NSLs, but they don't want to report too much because it actually makes them look bad. The other problem is that the NSLs in large part affect not their customers in the United States, but their customers overseas. So it's bad for their overseas business as well. So it's a very, very difficult set of problems we're facing now. And it shows you the way in which the government's decision to invest heavily in surveillance is creating strains on what we might call First Amendment doctrine. Last thing I want to say, and then I'll let you go. How many of you have heard of the idea of chilling effects in First Amendment law, right? Yeah, it's like outside right now, chilling effects, right? So 20th century First Amendment doctrine is organized around the problem of chilling effects, which is if the government regulates you or surveils you, you'll be chilled from engaged in valuable expression. And that's still true. That hasn't gone away. But when you combine prior restraint with the surveillance state, what you get is a new interesting idea. In most cases, the government would like its surveillance to just sort of be in the background. And it doesn't really want you to pay much attention to it. It mostly doesn't want you to get anxious. It wants you to keep writing your Facebook posts, keep calling your friends, keep traveling from place to place with the GPS enabled on your phone. It basically just wants you to keep living. So that in the surveillance state, instead of the government wanting to produce chilling effects, it just wants you to chill out. And that's what I want you to do now. Thank you very much. Chill out. You can go ahead whenever you're ready.
Okay. Thank thank you very much for...
Take a mic.
Oh, yeah.
Oh,
All good? Thanks, Jonathan. Want to see...
Forever.
Snooze.
I knew those skills would pay off.
So thank you very much for inviting me here. I'm really excited to be here. I love this paper, and I really love the idea of the focus on the changes in the infrastructure and the categorization of old school and new school regulation. And so I want to talk about that. But Roni and Olga have told me to not make this a big love fest and to focus on some areas in which we disagree. And so I'm going to try to do that. And you can see that I have a different focus than Jack, because as I say, I'm still dancing. I'm still excited about the continued efficacy of these two Supreme Court cases that we're here today to discuss, New York Times v. Sullivan, and especially New York Times v. United States. So I want to talk a little bit about the ways in which especially the prior restraint doctrine is still doing some important work in the context of new school regulation. Jack identifies the cause of the weakening of the impact of these First Amendment precedents to be primarily focused on the changes in the infrastructure of free expression and in cooperation between governments and the private entities that are responsible for the managing the infrastructure of this free expression. He also focuses in his paper on the various informal methods of control and delegation of speech to private parties and enforcement techniques that route around the important traditional procedural guarantees that the First Amendment doctrine has embodied. I want to make a few points in my brief remarks, and I'm going to try to be especially optimistic. Right? I've written papers in which I'm critical and very concerned about private dominance of the information infrastructure, but I'm going to try to be particularly optimistic in my remarks today. So first I want to say that regarding prior restraints, I think we have some reason to believe that the First Amendment prior restraint doctrine will still be efficacious in connection with new school regulation. I also want to compare it to other Western democracies, compare where we are situated compared to other Western democracies. I also want to emphasize that our First Amendment precedent and values are increasingly informing international free speech protections. So I'll talk a little bit about that as well. And finally, I want to focus on information, the ways in which the First Amendment precedents and values are informing ICT industry self-regulation. And in this way, industry players are, I think, resisting some of the co-optation that Jack talks about in his paper. So maybe one of the reasons why I'm still dancing is that I'm not really focusing in my remarks on national security issues. I'll leave that to others to focus on. I'm focusing more on content regulation, both in the United States and in other countries. So that's sort of an outline of my brief remarks. When I was reading about new school regulation and about whether the First Amendment prior restraint doctrine is and other doctrines are still significant and important in connection with new school regulation, I was thinking about this case from 2004 called Center for Democracy and Technology versus Papert, which you may be familiar with. I think this is an example of new school regulation, but we can discuss that. In this case, there was a Pennsylvania law that required ISPs to block or to take down content on or accessible through their servers upon receiving a judicial order, an ex parte judicial order, upon the submission from an attorney general that there was probable cause that the content was child pornography, Or, as it turned out, the way this was implemented was upon receipt of an informal notice from the Attorney General that the content identified was child pornography, and that would be absent a court order. And the requirement was that the ISPs take down this identified content within, I believe it was 5 days, or else themselves be criminally liable. Okay? So, a lot of problems with this law, and I think one of the problems with the law presents was the danger of collateral censorship, right? Because the law would hold the ISPs criminally liable if they refuse to block or take down this content for Pennsylvania subscribers within a certain set period of time. And yet, despite the informal nature of the request, these sort of informal notices from the Attorney General, and despite the fact that child pornography is clearly not protected by the First Amendment, despite the fact that the law contemplated a judicial determination, even though it was an ex parte one, the court found that the Pennsylvania Act constituted an unconstitutional prior restraint. Among its many other problems, the court said that this mechanism of holding the ISPs criminally liable for being unable to filter the child pornography constituted an illegal prior restraint. The court said that the procedural protections here were inadequate, even though we've got a judge, the statute contemplated a judge making a determination, because these were insufficient procedural protections under the prior restraint doctrine. The judge could make the determination ex parte without the publisher or distributor receiving notice or having an opportunity to be heard. So failing those basic procedural requirements of prior restraint. The informality of the notices to the ISPs did not save the act. Actually, the ISPs went to the Attorney General and said, we would actually prefer not to get an official court order. We would prefer to get an informal notice from the Attorney General. And so that's the way it was, at least in part, implemented. And the court, in deciding the case, said that despite the fact that these were informal notices requesting voluntary compliance, this is still subject to constitutional scrutiny. And this is actually kind of similar to something that I think we see in the Bantam Books case, which is one of our earlier prior restraint cases, where we had informal notices sent by an administrative agency to book publishers who were making available books that were harmful to minors, and there were requests for cooperation from the members of this, commission to protect the youth. The court in that case said that informal voluntary notices nonetheless can constitute unconstitutional prior restraints if they're unaccompanied by the requisite procedural safeguards. So I think the Pennsylvania case suggests that the prior restraint doctrine can still remain a powerful force in this context that would otherwise sort of allow for collateral censorship to work, right? Holding the ISPs criminally responsible if they don't take down this speech that was identified as child pornography. We also see in an older case, mainstream Loudon case, this is one where a public library itself implemented filtering software to block its patrons' access to child pornography material harmful to minors. The court in that case said this constitutes an unconstitutional prior restraint. And even not a happy case for me, the American Library Association versus United States Supreme Court case, in which mandatory filtering was upheld as a condition for library funding for both public libraries and public schools. Two of the justices, Kennedy and Breyer, who were concurring, whose votes were necessary, said that their vote depended on the ability of adult library patrons to request that the filters be removed, that these software filters be removed. So that that's not as happy of a decision, but I think that the Pennsylvania case is an interesting one and an important one for the continued viability of the prior restraint doctrine. Now, I'm particularly happy when I compare our First Amendment and our prior restraint doctrine and its force with what's going on in some other liberal democracies. I know others have written and researched about this topic. In the United Kingdom, there is an organization called the Internet Watch Foundation. That's a private entity that has the responsibility for maintaining a blacklist, a sort of evolving blacklist of websites that contain child pornography, what they call extreme pornography. The IWF also used to be responsible for maintaining a list of racial hatred sites. This has been going on for a long time in the United Kingdom. The blacklist affects 99% of internet users because ISPs are required to check the requested sites against the IWF's blacklist. And as far as I understand, there's no judicial supervision or notice or opportunity to be heard by affected websites that are blocked or individual internet users who are trying to access sites that are being blocked. And the UK is not stopping there, so you may have heard that Prime Minister David Cameron has a plan to impose mandatory nationwide family-friendly filtering by default on all computers by the end of 2014. Australia has also made some efforts in this regard too, of implementing mandatory filtering. The filtering, we were talking earlier this afternoon about safe search, so maybe there's some parallels here between what Google is doing with safe search and what the UK is doing. But so the implementation, I believe, is that the filtering option is ticked on as they say in the UK. By default, I want parental controls. Okay, and a whole host of categories of family-friendly content, of family-unfriendly content are being blocked. Right, so the usual suspects, sort of pornography, also things like anorexia websites. Esoteric material was one that I've seen. I don't even know what that means. Those are categories of speech that are blocked by these mandatory default filters. There are already instances of overblocking. The ISP TalkTalk blocked an award-winning British sex education site. It was blocked because it was pornographic. There was no notice that was given to the website that it was being blocked. So, you know, maybe this is kind of an unfair comparison, but by comparison, I think our prior restraint doctrine is doing some work here, as we see in the CDT v. Papert case that I discussed. I'm also happy that I think our prior restraint law, our First Amendment law in general and prior restraint law in particular, is having something of an influence in Europe, in the European Court of Human Rights jurisprudence, and under the jurisprudence of the International Convention on Civil and Political Rights, the ICCPR. So a recent case of Yildirim v. Turkey. I mean, Turkey is not a great friend of internet freedom, and an individual whose Google site was blocked brought a challenge before the European Convention of Human Rights, claiming that his free speech protections under the convention were being violated. And in this recent decision, one of the justices of the European Court of Human Rights cites the Bantam Books case, which I just discussed earlier, and says, to borrow the words of Bantam Books, any prior restraint on expression on the internet comes to me with a heavy presumption against its convention validity. So I think it's a good thing that our prior restraint doctrine and in particular its procedural requirements is having some influence. the UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression is also adopting some of our First Amendment doctrines, such as strict scrutiny for content-based regulations, focusing on the importance of judicial review in prior restraint contexts. So maybe we're not doing such a good job of implementing these requirements at home, but at least we're managing to export them to some degree to the European Court of Human Rights and to the jurisprudence under the ICC PR. I think I'm running a little short on time, so I'm not going to talk too much about CDA 230, except to say that, I'm quoting from Professor Tushnut's earlier article here, that the CDA gives, as we've discussed already this afternoon, it gives very broad immunity to ISPs for speech-based harms, and I think it completely removes incentives to collaterally censor. So I don't think we need to worry about that aspect of New York Times v. Sullivan's legacy being underprotected or under-enforced in the internet age. And I have some of the questionable actors here, right? These are the ISPs, websites like Don't Date Him Girl, which is a forum for writing critical stuff about your ex-boyfriend or your ex-husband, right? Including the allegedly defamatory stuff. So these cases have not reached full judicial determination, but I think if they did, Don't Date Him Girl would be able to say, hey, even though we specifically make available this forum for you to post potentially defamatory comments, we're not liable, right? We're not liable under 230. It's a case involving arms list, an online firearms marketplace in which a number of congressional amici wrote, look, providing blanket immunity for sites like this one is not what we had in mind when we passed the CDA, Section 230, but nonetheless, as we've already discussed, very broad and extensive protection and a check against concerns for collateral censorship, I think, in this context. Finally, I want to say a few words about the efforts of private speech intermediaries to resist co-optation and to resist invisibility and to increase visibility and transparency. So we were also talking about this during the break. I think, as we know, private speech intermediaries like Google and Yahoo and Facebook, they face a lot of formal and informal pressures to censor content, right? The Innocence of Muslims video, the United States government suggests to YouTube, don't you want to think hard, think again about whether this video violates your terms of service? Take another look at that, right? But I think that the case can be made that they're responding to these pressures in ways that are informed by First Amendment values, and this is kind of to return to some of Marvin's remarks, and that help to bring transparency and visibility to otherwise hidden government requests. Some of these organizations are voluntarily taking on commitments to First Amendment values. So this organization, the Global Network Initiative, which has been around for 5 or 6 years now, which was formed by Google and Yahoo and Microsoft, and is now, Facebook has recently joined. GW Law has also recently joined, so I'm just starting to get involved with this. Berkman has been involved, I understand, from the start. So this organization, the companies in this organization, including Microsoft, Google, Yahoo, commit themselves to principles of freedom of expression and privacy. And I won't read it, but they make a commitment to respect and protect these freedom of expression rights. They also agreed to sort of to put a little force behind this, to be independently assessed regarding their compliance with these principles. And the first independent assessment process was just completed. The independent assessment process reviews both formal and informal takedown requests and requests to censor. And the results of this independent assessment process were just released last month. So you might want to take a look at that. They evaluated Google, organizations like KPMG, PwC, et cetera, independently assessed Google, Microsoft, and Yahoo, and looked at the ways in which they responded to national security-related surveillance requests, requests for user information, blocking and filtering requirements, takedown requests, etc. And so they're voluntarily making themselves subject to these external assessment processes. I believe that they are also, some of them are, and some of the GNI members are committed to greater transparency and visibility regarding their decisions affecting speech. So, and we were also talking about this earlier, Google makes available its transparency reports. Microsoft and Yahoo have just recently begun to do so as well, in which they detail how they respond to government requests to take down and censor content. And Twitter also publishes on the Chilling Effects website the country requests to withhold content. So they're increasingly transparent, I think, and increasing visibility in their actions that are affecting speech. So here's just a bit from Google's transparency report that details government requests to remove content, requests for information about our users, requests by copyright owners, etc. And you can look at it. They go through country by country. Now, I assume that there are instances in which they are legally prohibited from making information available, and so that's not up there. But they do go through country by country and say, you know, Armenia asked us to remove a YouTube video that used profane language in reference to a politician. They asked us to remove it. We did not remove the video. Okay, so they go through and detail and provide this sort of transparency and increased visibility. And I think this is an effort to, you know, sort of resist co-optation that may occur from the government. So I think I'm happy about the fact that these members are committing themselves to greater transparency regarding their decision-making affecting speech and privacy. There's also a consideration of the implications of their technology on free speech and human rights. So looking, and this is something I think is really important to do and very difficult to do, to look at an early stage to see if the technology is being engineered to protect freedom of expression and privacy to the extent possible. So I think that our First Amendment values have inspired the free speech policies and commitments of these companies. And again, this is sort of picking up on something that Marvin was talking about earlier in his remarks. Finally, what is Spider-Man doing there? Well, I have a forthcoming article called "With Great Power Comes Great Responsibility," which talks about the principles of digital due process that these ICT companies should adopt in responding to countries' requests to censor content, to make available data about their users, et cetera. So I think that's sort of continuing the conversation that we began this morning. So these are the reasons why today I'm relatively optimistic and happy about the force of these foundational First Amendment precedents and values.
So, Dawn, thanks for helping us re-nook our belief in the First Amendment. And thank you, really, to the two of you for putting together a remarkable day, a really remarkable day. I think I'm operating on about 3.5 hours of napping in an upright position, more or less, on a red eye, and it's sitting on the edge of my seat. So it's really, thank you. One of my problems is that I read Jack's paper and I said, ooh, I wish I'd written that. So what I'll try to do a little bit is contextualize, connect it to some of the other papers, maybe push back a little bit on your optimism, Dawn, and not go on for too long, knowing that it's the end of a long day. One, New York Times versus Sullivan has a certain kind of lesson that comes from its period, which is to say it is a realist opinion. It's an opinion that tells us that a rule of private law, a venerable common law rule that regulates something that's not at all about newspapers or government censorship or anything like that, it's just the private market, is a rule that regulates speech. In that regard, it is a less virulent member of the embarrassing uncle called Shelley versus Kramer that said that enforcing standard property rules that end up in excluding, not end up, that explicitly exclude African Americans and Jews from a neighborhood is state action, and exploded the state action doctrine to such an extent that it remained on its own. It is to some extent a cousin of footnote 11 in Brown versus Board of Education. It's an understanding in the context of the First Amendment that the thing we care about with regard to speech is not a function of the law of censorship, only is not a function of the law of government officials deciding, but is also a function of some other system, in this case, private law adjudication that was considered unproblematic before and stopped being unproblematic. And it's that realism, that understanding that the law of the First Amendment may not be where the action is for the future of freedom of expression, that I think we need to take into the future from New York Times v. Sullivan, and came through all or most of the talks we heard today in various ways. And so, for example, there is no prior restraint, but the single most linked to post that explains the details of what the problems with PIPA were, on the single most linked to news site, TechDirt, over the course of the 18 months from the introduction of COICA until the defeat of PIPA in the Senate, was unavailable for search on Google for a month because it was included as number 300 and something or other on a list of over 1,000 links sent to Google as potentially infringing materials under the DMCA request. And it took weeks for Mike Masnick to just by surprise look for it on Google because he wasn't sure where it was, and realized that he couldn't find it, and then call them back and say, actually, you know what, this is just me criticizing SOPA and PIPA. It's not actually anyone else's anything. That's not about law and First Amendment, that's just about new school regulation. That's the kind of thing. And so the second thing that we take from seeing New York Times v. Sullivan as a relative of Shelley versus Kramer and Brown is that the dynamic that Jack describes for us, the fact that the same technologies of speech that allowed people to create speech around old models of constraint in the industrial mass-mediated environment of routing around and glomming on, as Jack in an earlier article talked about, those same infrastructures are also the infrastructures of surveillance and control. But I think it's important for us to understand that this is one of many instances. All individual freedom can only occur through systems of affordance and constraint. We don't operate in a vacuum. And these systems also in different ways enact power from different sources that constrain as much as they are capable of being allowing us to act. And so the phenomenon is ubiquitous. If we think of dignity and privacy and those interests, and you read Justice Alito's opinion or Justice Sotomayor's opinion in U.S. v. Jones, you see that the protection from state surveillance in the past is primarily cost and inefficiency of surveillance in an environment that is not ubiquitously impregnated with sensors and networked connectivity. If you look at and this is true throughout. So essentially, what we learn is that both the new capabilities and the new constraints are functions of the disruption from the older model. And so let's look at today's presentations. Susan starts us out by saying, what is the basis of free speech? She focuses on the negative, on the use of free speech to constrain regulation. But the underlying move is an underlying move to maintain an architecture where the bottleneck doesn't have control. The battle over the economic regulation of common carriage becomes more important to free speech than the battle over free speech, except in the sense that free speech can get in the way. Or if we look at Marvin's presentation, one of the fascinating things was the ways in which, and this is actually connected to GNI and how GNI is really very different from the First Amendment. The source of freedom that Marvin's describing is the organizational capacity of individuals, acculturated in a certain educational framework and mind frame of thinking about the relationship between technology and freedom, that didn't come out of anywhere. It was the object of contestation, of intellectual work, of public debate, around which a set of people grow up and say, this matters to freedom along other dimensions, and I'm willing to separate the interests of the market from what I understand to be my role as an individual in the organization. And you describe these people within the organization trying to tug and pull on these imperfect systems of power over how these organizations will work to implement a vision of freedom. This is not new. When you look at the New York Times, when you look at the Washington Post, what's unique about them? They're the papers that have this unique stock model that you described, to allow families that are committed to a model of professional journalism that could not sustain the tyranny of the margin to protect themselves from the tyranny of the margin and use the cultural framework that says I'm a professional journalist running a family newspaper protected from the tyranny of the margin. That's not the First Amendment. That is corporate law. That is a sense of cultural sense of duty and of professional norms, and to understand what is the source of freedom of expression, or in this case, what is the source of an effective functioning press, it's that combination of multiple system of constraint and affordance that only in combination actually deliver something like what we care about when we care about freedom of expression. And so the formal position of the US, you talk about international, about isomorphism and the influence of the US. But in the same way, the US is influencing all of the systems of public-private co-optation and of collateral censorship through the USTR, through the implementation of the same systems of collateral censorship by requiring them in bilateral trade treaties, by trying to push them through in ACTA. And there's a beautiful map of the ways in which the anti-SOPA PIPA debate here ripples through in February as it ends here in January, ripples throughout Europe and leads to the blockage of ACTA in Europe as people are influenced by this tremendous surge to block it. And Marvin played a central role in the network of people who blocked SOPA. But then again, where do you see the role of someone like Michael Geist, one professor sitting in Canada, providing a bridge between these two communities and a mapping of this political map onto that? It's that set of systems and their interaction. And it's the breakage of that set of systems that you're describing. And so just to focus on a couple of the things that you described, because you focused on the First Amendment doctrine comparisons in the sense of prior restraint, and I just want to bring out a couple of things, at least in the conversation from the paper, that were very rich. First is the significance of the rise of the mobile handset and cloud computing as a risk to the architecture of free expression in the networked environment. Over a decade ago, Eben Moglen talked about free speech is not so much enforced or recognized or protected anymore as much as implemented. And implemented through systems that were built on open standards, ran on unowned infrastructure, and deployed at least in an environment that allowed the interjection of uncontrolled software, standards, and content all the way through. Once you move on one hand to the mobile handset with its proprietary standards, you're in an environment where Apple can decide to exclude from the App Store a game that mocks its labor practices in the production of the iPhone, which it did. It allows Apple to take off an app for reading WikiLeaks cables, which it did. Once you move to the cloud because of its convenience, you've moved from distributed storage to centralized points of control that then become points of intervention for precisely the kind of soft power that you described with the Lieberman intervention, with the Coe intervention. So again, there's a moment at which what's happening is not a self-conscious government move to change controls, though that exists too sometimes in some contexts in this, but not in this case, but rather a change in the market dynamics of the technology that is shifting us for reasons that have to do with convenience and cost to an infrastructure that is vastly more regulable, as Larry Lessig called it over 15 years ago. That's a central threat to freedom of expression, even though it doesn't touch the First Amendment with a 10-foot pole. And it is a more important, and this is back to Susan's original point, it is a more important threat to freedom of expression than all of the doctrinal questions. They're marginal because they don't matter, because they happen underneath where things happen. Let's move away from the internet for a moment to make that intuitive. A young woman who wants to express herself about sexual self-control and her sense of self through dressing. In the right or wrong society, the threat of being killed, battered, or have acid poured on you by your father, your brother, or someone else is vastly, overwhelmingly more of a constraint on freedom of speech than even an authoritarian government that doesn't care about this particular thing but about something else, simply because of the closeness of surveillance. And to say that isomorphism in institutions of the formal state is an improvement in freedom of speech of women in that particular context seems to me to be missing the point. And so the question is, if that's intuitively correct, how do we apply to the infrastructures of expression in contemporary and future society across all of these domains? And that's what I see as so valuable about the map that Jack is offering us. So just to conclude, this is to some extent a theory of freedom of expression, but more foundationally, it's a theory of freedom generally for people such as we are, situated in multiple overlapping systems of constraint and affordance, without which we cannot act autonomously because we cannot act effectively at all. And yet, as these systems provide us with affordances, they also provide others with channels of power to implement on us. And the essence of freedom is the capacity to read these multiple systems and to be able to map where we can bob and weave between them, where we can leverage power from one system, be it the organization of the lawyers, be it the ethic of the press, be it the technology of free software, whatever it happens to be. Leverage it into the other systems in order to avoid power along some dimensions and create opportunities along others. That's where freedom is. Any focus on any single one of these to the exclusion of others risks blinding us to where the action really is.
Do you want to respond?
Let's do questions.
Okay. So I'm going to intervene at this point because I want to say something provoked by Yochai's invocation of Shelley and Kramer and the realism of Times and Sullivan and the, I don't know, contrast or the linkage he drew between that and Professor Crawford's presentation this morning. Okay? So as a doctrinal matter, the way to handle all this stuff is through some return to, revitalization of the realism of the state action doctrine that underlay Shelley and Kramer. And then, actually, I think lots of these things become handleable as a doctrinal matter. Now, getting back to Shelley from where we are on the doctrine of the state on the state action doctrine is not easy. I mean, it's not. I'm imagining the sequence of decisions that leads from Brentwood Academy to realism about internet. You can imagine it, but it would take work to do. Okay, that's one. The second observation is actually also about realism, which I would connect to the post-New Deal vision of the Constitution, which the shorthand would be the post-New Deal vision was a vision of statism, which is fine for Professor Crawford, and then problematic with respect to this kind of the surveillance state, for example. But the realists' resolution of that tension was to say, yes, we are statists. The location for the discussion of, or the resolution of all of these conflicts is through ordinary politics, not through constitutional adjudication in the courts. And that includes politics about the structure of politics itself. I think that's the legal realist, the old-time legal realist version of what Professor Benkler was talking about all of these, the way in which these difficulties are and ought to be resolved. Okay, so that's my spiel. Now, comments, questions? Yes, David.
The First Amendment is to remain relevant at all to helping to shape the architecture of free speech in the future. Doesn't it require, first, a different conception of state action? Second, moving away from the litigation model of the individual challenging a particular governmental action?
Well, yes, I think the answer is yes. A lot of the things I talk about in the paper, you could adjust by simply revamping the prior restraint doctrine. And a lot of the paper is just showing you how, if you take what the prior restraint doctrine is about, you can attack certain kinds of things. But to follow off on the point that Yochai made, many of the problems we face now are either problems of regulatory structure. That is what Susan's talking about. If you start with a particular kind of regulatory regime, then the First Amendment problems don't even arise, because basically you've just designed them in a certain way, and you want to keep the courts out of that regulatory design. And a still deeper set of problems have to do with the way in which the technologies develop. There's no First Amendment right to not move to cloud-based computing. There's no First Amendment right not to develop smartphones, to take the two examples in my paper that Yochai was talking about. These are, the Congress isn't even the right venue to have that discussion. You know, that discussion has to be a discussion in terms of business and how business is organized and what kinds of designs they make. So another way of putting your remarks together is that if you were going to have a truly realist conception of information policy in our age, you would need the collaboration both of technologists, right, in terms of design, Congress and administrative agencies in terms of the design for regulatory apparatuses, and you would also need judges, but who would understand how to get out of the way, and not to think that they had to solve everything through the articulation of First Amendment doctrine.
Just to add one thing, which is I could imagine the First Amendment playing a partial role, a role that is strategically deployed in a particular historical context by people who act strategically, and sometimes by judges who understand an understanding of the implications of what they do in the context of the history and this multi-overlapping system, and thinking of law in that regard. So, for example, when Susan describes the counter-argument to the Verizon claim about the First Amendment right to not be constrained from editing the internet, that's a First Amendment move, both by the company and by the people opposing it, that is played out within the aesthetics of the traditional First Amendment, but everybody actually understands that what's going on is over here and what its implications are. I'd say let's say 12 to 14 years ago, there was a period where the 2600 case through the Eldred case, there was a whole set of us pushing a First Amendment challenge to first the Digital Millennium Copyright Act, then the Copyright Term Extension Act, but in general an effort to bring copyright into the Turner framework. And to force copyright law to account for itself and its on higher terms than rationality. And when Judge Newman basically said no, and when Justice Ginsburg basically said no, they had massive implications for the architecture of free speech, but didn't know it. So it's a much more, so your solution is pushing us towards, if we were to rewrite, as Jack says, First Amendment doctrine so that it in fact encompassed all of these things, we'd need those things. But if we were to accept that the province of law is actually much narrower than it originally was given, but is only one section among others, and the interaction between the First Amendment and people operating with society is always playing the game on multiple boards, and knowing how you move here affects over here, that's a different attitude toward it and a different attitude of lawyering. But I don't think it makes the First Amendment irrelevant. It just makes it relevant in a very different and more limited way.
Sir?
So let me just muse on that. This may or not be any sort of question, but just picking up what Yochai was saying and thinking back to Jack's presentation and thinking back to Mark's opening about how we all come to the First Amendment. You know, if we imagine the counterfactual world in which we actually never had a First Amendment, had never been enacted, it wasn't part of our traditions, it was more like, we were more like Britain, would we think about Jack's examples differently? Does it bother us in part because we have this background in our mind of what the First Amendment means, and so when we feel like there are these restrictions that are being imposed in these new ways, it feels wrong to us, such that if somebody responds by saying, well, you can go get legislation, we think that, but that's not, no. We're supposed to get this in the Constitution. We're not supposed to just get this through mere legislation or sort of ordinary, sort of pressure on companies. And so I'm just sort of thinking aloud to what degree because we have this background of the First Amendment, we want to elevate the problems that Jack is talking about, when if we didn't have it at all, we might see it as just another set of problems that we deal with in the ordinary political realm, no more, of no necessarily greater concern or difficulty than lots of other problems that we would deal with. So maybe the very short way of thinking about this question is, how would the how would the Brits who had a similar kind of perspective but no First Amendment react to this, to Jack's paper and to Don's comments on it?
I'm going to. We should distinguish between the issue of judicial review and judicial protection of the First Amendment and the existence of a text called the First Amendment. Oh. Hello, how are you? We should distinguish between the existence of a text called the First Amendment and the power of judges to create doctrine implementing that text. Okay? That's really important to what I want to say. Yochai and I were talking at the break. Modern First Amendment doctrine as we know it is really a product of the second half of the 20th century, and it actually is created in two short bursts in the 40s and then again between about 63 and 76. Before that, there is no doctrine of the First Amendment, or there is, it's very limited. Most of the First Amendment is basically it's understood in customary norm-based common law terms. Look at David Raban's history and also Michael Kent Curtis's People's Darling Privilege, which is a wonderful book about struggles over free speech. Most struggles over free speech throughout most of the country's history were resolved politically, right? So there were fights over the post office. There were fights over the gag rule in the House. There were fights over contraception. There were fights over labor unions. There were fights over imprisonment for saying things that the president didn't like. So they weren't done in the way we think of it today, which is the development of judicial doctrine. You did have a text, right? You did have something called the First Amendment. You could point to it. You could talk about traditions of free speech in America, right? But it's all basically done through politics. And it's really only second half of the 20th century that you actually develop the kinds of doctrines that allow you to rationalize it, right? The Brits, too, by the way, did have a principle against prior restraints. That was, for them, the central principle of free expression, or free press, really. There's a sense in which the 20th century was an aberration in understanding how freedom of expression works in America. We are, in a sense, retreating or returning to the problem that was faced through the first 150 years of the country, which is how do we build out the infrastructure of free expression, telegraphs, for example, railroads, in such a way as to preserve the values of free expression without the benefit of courts. And one of the interesting ironies of having a celebration of New York Times versus Sullivan is that New York Times versus Sullivan represents that moment in which we hand off most of the work of doing this to the courts, and they respond in these bursts of doctrinal evolution. But now, 50 years later, it looks like a lot of the heavy lifting will have to be done by other parties, and it'll have to be done in politics.
Again, I want to respond to Stuart also because, to some extent, we actually know what the Brits would do because it's what they did after Times and Sullivan, right? And the answer is, first of all, there's always law, okay? But law is the common law set of entitlements created by background rules of property, contract, and tort. And those background rules can be adjusted in the ordinary way by thinking about the purposes of what you're trying to achieve. I mean, that's the realist part of it. And subject to legislative revision, okay? And the invocation of the common carrier idea is exactly that. Now, in the U.S. it gets complicated because the common carrier idea is going to be a rule of federal law, which it ordinarily wouldn't be, but you can work on that. That's a relatively easy thing to do. I think what unifies at the very least the first and the last panel is the tension between, which I think ultimately is not a true tension, between a state action doctrine that shunts consideration of these background rules into the Constitution and a direct consideration of what the background rules should be. Yeah.
So something that's been touched about a lot is the idea of state action and seeing, whether courts are going to have to start looking at things that Facebook or Google do through a different lens. But I'm sort of wondering if what Professor Benkler and a lot of other people are saying, the action is clearly moving in the direction of private restraints on speech being more problematic and more concrete than public restraints on speech, then it seems like the action is going to move towards legislation that is designed to force open channels of speech that private entities might foreclose. And so how well is the First Amendment suited in this doctrine that we've developed from this very, Congress shall pass no law conception of the First Amendment? How well suited is it to evaluating those sorts of situations where the government is operating on a private party that has its own speech interests with the overarching purpose of enhancing speech?
Starting to chew gum, sorry. Well, I think that's sort of what we were discussing this morning, right, in connection with Susan's comments. And I asked a question too about Turner and the implications of Turner for net neutrality regulation, right? So I think that's what you're talking about, right? If suppose we have net neutrality legislation that's passed by Congress to require our private broadband providers to not discriminate against any of the traffic, right, that they're responsible for. And so the free flow of information is required to be protected by these broadband service providers. So maybe the question is, how well is the First Amendment able to deal with a challenge that the broadband service providers might bring, that Susan was talking about, that Verizon, I believe, articulates in its briefs in the Verizon v. FCC case, that, hey, you're discriminating against us, right? And this is this regulation is a violation of our speech rights. And I was suggesting that, if it comes to that, I think that even if the courts were to acknowledge that these broadband service providers have some sort of free speech interest, I think Turner would look to that net neutrality regulation as a content neutral regulation. So we'd have a sort of a lower level of scrutiny and intermediate scrutiny. And I think that there's a good case to be made that net neutrality regulation would survive that Turner intermediate scrutiny. And if you look back at Turner, one of the important state interests that the Supreme Court credits is protecting information from a multiplicity of sources and allowing for sort of widespread dissemination of information. And I think that those sorts of interests would very much be at stake in net neutrality regulation.
I understood your question a little bit differently, and I'm going to use it to make two discrete points in response. The first is, I think a powerful part of the paper is the rejection of the premise that the kind of multi-system approach that I suggest implies that private regulation becomes more important than public regulation. I think the sophistication of the public-private partnership of censorship, and once you look at surveillance, it's really much broader, a public-private partnership of social control, is the reciprocity between the small number of players who have the capacity on the private side and the public side to use each other's capacities to pursue their respective projections of power, be it the surveillance state, be it the acquisition of more profit, be it the manipulation of demand through advertising networks and shaped search. So it's not just about private parties getting and private censorship. It's the greater capacity of some private actors and some public actors of sufficient sophistication, both of them, to use these systems to impose more. That's the first. The second, I thought I understood you, and perhaps I misunderstood you, as suggesting, can the First Amendment be a source of constraint on private action, which goes back to the question of whether we have to change state action. And there, if we don't do that, really that's the battle that between 68 and 74, after Red Lion, many fought, and Jerry Barron wrote about it, and ultimately the court tried to kill in Miami Herald v. Tornillo. I think that's going to be very hard, but I also am not confident that that's the right way of thinking about a First Amendment fix. The fix is, here's a menu of strategies. Some of them are legal, some of them are not. Some of the legal ones are constitutional, some of them are not. There's a historically contextual and very practical way in which we throw these particular tools at the problem to get the outcome we want, which is a greater degree of freedom within the systems as they interact. At which point, okay, so that's a particular constraint of the doctrine, that it won't let me do this, but let me do that.
One last thing. It's so much more likely in the next 20 years that the First Amendment will be used to prevent reform.
Susan, didn't you?
I think I hear Mark should be saying it may not be that the First Amendment ends up being all that relevant if we move to this idea of achieving ends that are important to society in America, and that all of our wondering about the doctrine might actually be we're fighting on the wrong battlefield. That to move over to the status view might be the way to go. Do I misunderstand you?
No, that's exactly right. Okay, well, oh, was there, sorry, I didn't see that.
There we are. Hi, I was going to ask a question before, and I'm going to say, I'm going to put my activist on, which activist hat on, which was for me sort of like cursing at the Harvard Law Review Symposium. But I'm just, as a comment, I'm just super staggered that that's probably where we're going to end. I just wanted to make a short comment about positive obligations under the European Convention of Human Rights. Where in the last couple of years there have been quite some interesting developments. In the case of data security, there's a positive obligation for European member states to warrant that on the actually Finland case. There's a couple of months ago, in the field of privacy, there's been a ruling on that all cloud data, regardless of whether it's personal or not, falls under its scope, and that member states have to adopt legislation to protect data in the cloud, regardless of whether it's personal or not. And then in freedom of expression, in the Netherlands, we have net neutrality legislation in place since, well, for 3 years now. And the main argument there was Article 10 of the European Convention of Human Rights. So actually that there's a positive obligation for legislatures to adopt legislation in this field. Now, of course, the First Amendment has a very long tradition of negative freedom as opposed to positive freedom. I just wondered, as a final question, or you can have it over a drink or whatever, but do you ever see, or do you ever envision, in maybe a long-term future, that this traditional stance of negative freedoms and in doctrine, which I get the impression is very much limiting freedom of expression in the future, where the freedom of expression is basically as strong as your weakest intermediary. Do you ever see that envisioned, like in maybe 10 or 20 years future, that there will slowly but surely be a transition away from solely basic freedom and these negative rights, also into positive obligations, or is it completely not going to happen in the avenue of the Constitution?
If I were to guess, it would probably happen through the development of judicial restraint, not through the enforcement of constitutional norms by courts, but rather through judicial restraint. There are some exceptions in American doctrine. The doctrine of public forum, which is actually a doctrine of access, to government property is an exception to the basic rule. There are also limited rights of access to very traditional court proceedings, which also have been achieved through the First Amendment. But the American free speech tradition has protected positive access to freedoms, generally through a combination of custom and legislation and institutional reform. That's the way it has been up to this point. I suspect that's the way it'll continue to be.
Okay, so now.
Wait,
Oh, no.
You can't end without talking to Marvin.
Okay, Marvin.
So while listening,
Gotcha. So while listening to the discussion of courts and Congress, and in response to that last question, it just occurred to me that would our answer be different if the courts were more favorable to arguments? Like, would we be all championing the idea of going to the courts to bring certain cases if we thought we could win them? I mean, I'm all in favor of forum shopping and choosing the best avenue. But I feel like, would you guys have a different answer if the courts were more sympathetic to some of the arguments we have?
You realize, Marvin, that if the courts were more sympathetic, they would basically dismiss the challenges.
Well,
Sure, but let's say surveillance. You know, let's
Right.
say surveillance is
Oh, surveillance, right. Yeah, so it's possible. So just to take the point of your last question, is it possible to use the negative traditions of freedom in America as a way of protecting the ecology of free expression? Yes. The answer is there was a missed opportunity in 1971 in a case called Laird versus Tatum, in which the Supreme Court refuses to develop a First Amendment jurisprudence against surveillance. This is a negative liberty. Instead, it's all developed through the Fourth Amendment security. We could, in fact, develop a negative liberty jurisprudence of the First Amendment, which would protect freedom of association against certain forms of government surveillance, yes. And it could happen again. We'll see. It'll probably happen through the Fourth Amendment, but stranger things have happened.
I think that the answer is just look at how we've been in the last 20 years, right? So we fought 96 to 98, the captured Clinton White House in its copyright expansion legislation, and lost disastrously in 98. Moved to the courts, lost disastrously between 2000 and 2002, and then moved to culture and technology. Right, to Creative Commons, to the free culture movement, to peer-to-peer file sharing, to a variety of other techniques. The answer is, to my mind, consistent with a multi-system view of a substantive commitment to human freedom and a pragmatic Catholicism about the particular system through which you can work, given its openness at a given historical moment.
Now I will. I'm actually really scanning the room. So I want to close by thanking, on behalf of the panelists and the people in attendance, the Law Review and Ronnie and Olga. And you want to say something at the end?
So we're not totally done yet. There's dinner at 6, but before that, we want to take a short break and then invite all of the speakers and all of the commentators to come up front and have an open discussion about...
Oh, my gosh.
But before that, can we just say thank you to you?
So we'll take a really short break. Don't leave, because this is going to be the best part.
What was wrong with this one?
Not everybody will get to answer.